So the first two panels were devoted to the emergence and affirmation of natural law in politics and the construction of political norms, not only as everybody says, not only theoretical, but also and mostly perhaps practical. Natural law is not only in books, but perhaps first and foremost a tool, as Mark says, a tool for action. And of course, in Revolution, the tool is at the first place. So with this third panel, we enter in the time of revolutions characterized by the implementation of political norms based on natural law and to organize human societies. As you know, in revolutionary France, because it will be the subject of the three papers, in revolutionary France, this period of affirmation of natural rights gave rise to the Declaration of Rights of 1789, and which was extended with the Declaration of Rights of 1793. These declarations are the foundation of political association that highlight the fact that the human beings who make up a society have entered into a contract with each other to guarantee their natural rights, as stated in the Article 2 of the 1789 Declaration. I quote, "The aim of all political association is the conservation of the natural and imprescriptible rights of man." The function of government is to guarantee this. As stated in Article 1, government is instituted to guarantee to man the enjoyment of his natural and imprescriptible rights. And the Declaration of Rights and Man and Citizen is an important part of the title. The Declaration...
Recording in progress.
Silenzio. The Declaration gives each contractor the means to guarantee his right by establishing him as a citizen. So, and as a citizen, each contractor must check whether the contract binding him to other is being respected by the government. So, as a citizen, he must check whether society is still constituted or whether, on the contrary, is he living in a state of war, as in the sense of Locke. In a book published in 1956, the philosopher, both French and German, perhaps, Bernard Groothuissen, explains that during that declaring the natural rights of man committed the French Revolution in an increasingly revolutionary logic. And this immanent logic, and to use Groothuissen expression, was stopped in 1795. Stop in 1795 when all the democratic possibilities that had been opened up since 1789, when all these possibilities began to fold. And after, from 1795, for the dominant conception of political theory, declaring natural rights was now deemed anarchist. I'll come back on this in the conclusion. And the free paper we are about to hear are interesting because they take a step. I think aside from this narrative, and for this reason can question this narrative. For instance, Valentina Toppiedi dell'Università dei Studi di Torino. You will address what we might call the missing revolution with a question mark. And the question is, are women the forgotten ones in this narrative of declared natural rights? And the two other papers, Laura André, Université de Paris Panthéon-Assas, et puis Andrea Moretti de l'Università di Udine et Trieste. The two other papers will take us beyond this narrative, in fact, because Laura will deal with the so-called ideologues, both Republican theorists and politicians who are hostile to declared natural rights. And Andrea will also place us at the end of this narrative with the Cisalpine Republic, so 1796, 1799, where natural rights are apparently still mobilized, whereas they have been eliminated in France. So.
I would like to start my presentation with a well-known quote from the Rigoletto by Giuseppe Verdi. La donna è mobile qual piuma al vento, muta d'accento di pensier. Woman is flighty like a feather in the wind. She changes in voice and in thought. It's a catchy tune, we all know. It has been used in popular culture for a very long time and for many occasions. This analogy between the woman and the feather in the wind was already used by Victor Hugo dans Les Rois s'amusent, where it is said that une femme souvent n'est qu'une plume au vent. So the question is why I started with this quotation. Because this assumption about the female fickleness is one of the heaviest prejudices that women had to fight over the centuries. Recently, Giulia Sissa has analyzed the history and evolution of the distinction between the sexes in the European political thought, and in particular, she has pointed out the crucial steps in the definition of a rigid feminine nature opposed to the male one. It is a distinction that is already found in classical Greece and that Aristotle organized into a system of thought. The male is fiery, impetuous, bold, imperious. The female is cold, intelligent, but coward and timid. Man is a political animal, woman is a domestic animal. This distinction was inherited by Christianity, which accentuated its characteristics. While the ancient woman is irresolute because her body is not sufficiently warm, she does not have sufficient humus to act and to pursue her own objectives or to fight like men, the Christian woman becomes irrational because emotion have the upper hand over reason. She literally let herself be carried away from one judgment to another. The 18th century represents another watershed moment in this history. The idea of rights that belong to human beings as such begins to spread, yet prejudices against women persist. The failure to constitutionalize the rights of women in the context of the American and French Revolution, as well as the perpetuation of slavery, represent very well the difficult transition from natural rights to human rights as moral and political rights, as Ferrone pointed out. Provocatively, Olympe de Gouges denounced in her Declaration of the Rights of Woman and the Female Citizen, at the very moment in which the French Constitution was promulgated, the failure to universalize the rights solemnly declared in August 1789. In the first article of her declaration, she stated that woman is born free and remains equal to man in rights. Social distinction may be based only on common utility. Furthermore, in the fourth article, she pointed out that the exercise of the natural rights of women has no other limits than those that the purple tyranny of man opposes to them. These limits must be reformed according to the law of nature and reason. Indeed, the old Declaration of the Rights of Woman is based on the contradiction between the laws of nature and the positive law. The Gouge strategy is particularly clear if we compare her declaration with the original of 1789. In fact, in the original fourth article, the revolutionary stated that liberty consists in the freedom to do everything which injures no one else. Hence, the exercise of the natural rights of each man has no limits except those which assure to the other members of the society the enjoyment of the same rights. These limits can only be determined by law. More clearly, the sixth article showed this tension. While the deputies of the National Assembly stated that the law is the expression of the general will, every citizen has a right to participate personally or through his representative in its foundation. It must be the same for all, whether it protects or punishes. All citizens, being equal in the eyes of the law, are equally eligible to all dignities and to all public position and occupation, according to their abilities and without distinction except that of their virtues and talents. The Gouge denounced the lack of universality, specifying that the law should be, and so it is not, the expression of the general will. All citizens and citizens should take part in person or by their representative in its formation. It must be the same for everyone. All citizens and citizens, being equal in its eyes, should be equal admissible to all public dignities, offices and employments according to their ability and with no other distinction than that of their virtues and talents. The aim of Olympe de Gouges writing the Declaration of the Right of Woman is to uphold the natural rights of women, which are, as stated in the second article of her declaration, the same of men. These rights are liberty, property, security, and especially, she added, resistance to oppression. But de Gouges was not the only one to speak on women's behalf. Even before the publication of her declaration, Nicolas de Condorcet pleaded in a certain sense the same cause. In the essay on the admission of women to the rights of citizenship, Sur la mission des femmes aux droits de cité, published in the summer 1790, in the Journal de la Société de 1789, he sustained the equality of right between the two sexes. Condorcet introduced his claim with an original reflection about the power of habit. He said, habit can so familiarize men with violation of their natural rights that those who have lost them neither think of protesting nor believe they are unjustly treated. Between these violations that have escaped the notice of philosopher and legislator, there are, in Condorcet's opinion, the rights of women. In fact, is he asking himself if the legislator have they not all violated the principle of equality of rights in tranquilly depriving one half of the human race of the right of taking part in the formation of laws by the exclusion of women from the rights of citizenship? In order to show, said Condorcet, that this exclusion is not an act of tyranny, it must be proved either that the natural rights of women are not absolutely the same as those of men, or that women are not capable of exercising these rights. But it explained that the rights of men stem exclusively from the fact that they are sentient beings, capable of acquiring moral ideas and of reasoning upon them. Since women have the same quality, they necessarily also have the same rights. Either no member of the human race has any true rights, or else they all have the same ones. And anyone who votes against the rights of another, whatever his religion, color, or sex, automatically forfeits his own. Therefore, Condorcet orderly demolishes the arguments used by his contemporaries to justify the exclusion of women from the enjoyment of political rights. First of all, he denies that their passing in this position affect the reason capacity of women. Otherwise, he adds, they would also have to deprive of the right to vote men with gout or who are frequently ill. Secondly, even assuming that men have a superiority of spirit that is not due to education, which remains to be proven and should be proven, as Condorcet, in order to deprive women without committing injustice of the natural right to education, this superiority consists of two aspects. That is, on the one hand, the absence of women of genius, and on the other hand, that no woman has the same extent of knowledge and the same power of reasoning as certain men. In Condorcet's opinion, this argument is also invalid because, with the exception of a limited number of exceptionally enlightened men, equality is absolute between women and the remainder of the men. That is, that this small class apart, inferiority and superiority, are equally divided between the two sexes. Lastly, Condorcet asks if there exist in the minds and hearts of women certain qualities which ought to exclude them from the enjoyment of their natural rights. To answer this question, he interrogates the facts and mentions Elizabeth of England, Maria Theresa, and Duke Catherine of Russia, which very clearly have shown that women lack neither strength of mind nor courage. He even adds a series of examples of counterfactual history, we would say, to demonstrate that women in power would perhaps have legislated better than men. The quotation is in the slide, I only read a few lines. Would Mistress Macaulay not have argued better in the House of Commons than many of the representatives of the British nation? Could the Marquise du Châtelet not have written a dispatch just as well as Monsieur Rouillet? Would Madame de Lambert have accepted such absurd and barbarous laws as those passed by d'Armenonville? He concludes, Condorcet, that men have no real reason to be so proud when they cast their eyes over the list of those who have governed them. In the second part of his argument, Condorcet addresses the theme of women's fickleness. In his opinion, women are more gentle, more domestic than men, but it is untrue that never base their conduct on what is called reason. He said, they may never have behaved according to the reason of men, but they do behave according to their own reason. If we delve deeper into this aspect, we discover that in reality, Condorcet does not theorize a difference in terms of reason between men and women, because he explained that this difference is caused not by nature, but by education and society. Men and women have different interests and objectives, both due to laws and different education. So he concludes that it is quite unfair to justify continuing to refuse women the enjoyment of their natural rights on grounds which are plausible only precisely because they do not enjoy these rights. In fact, he adds that if they accepted such argument against women, they should also have to deny citizenship rights to anyone who was forced to work constantly and could therefore neither become enlightened nor exercise his reason. By admitting this principle, any non-aristocratic constitution would be dismissed. Finally, Condorcet addresses the issue of the opportunity and usefulness of granting political rights to women, specifying at the same time that usefulness cannot counterbalance what he defines a true right. In fact, he said that it is in the name of utility that trade and industry are fettered and Africans enslaved. It is in the name of public utility that the Bastille was filled, that books were censored, and that judicial proceedings were kept secret and the people were tortured. First objection concerns women's influence on men. But this influence, like any other, in Condorcet's opinion, is far more of a threat if it acts in secrets than if it acts in public debate. Disregard the typical 18th century idea of the female machination in the wings behind the scene. The second objection is that this change would contradict general utility because it would distract women from the task which nature seems to have reserved for them. According to Condorcet, this objection is also not justified because the current degree of civilization of the European nation means that a very few citizens can deal with public affairs, and women would be no more forced to abandon their homes than laborers their plows or craftsmen their workshops. But the real issue behind this objection concerns obviously motherhood and childcare. In this regard, Condorcet admits that this may be a reason not to elect them, but it cannot form the basis of a legal exclusion. Moreover, he adds that giving women rights of citizenship would make them better able to raise their children and to make men of them. In conclusion, Condorcet proposes to extend the right of citizenship to women who own property and who are the heads of their households. The central idea of this text is therefore that women and men have the same natural rights because these rights belong to the nature of human beings, but they find themselves in different conditions due to education and society, which has long placed women in a subordinate position. The same idea of a natural equality between men and women erased by society is also at the center of another text much less known than one of the Gouges and Condorcet, but not less important. In 1790, Marie-Madeleine Jodin addressed to the French National Assembly a legislative proposal to ensure women political rights. In her Legislative View for Women, Vue législative pour les femmes, adressée à l'Assemblée nationale. She claimed for women the honor and the right to contribute to public prosperity by breaking the silence to which politics seems to have condemned them. In order to shed light on Marie-Madeleine Jodin, who is amongst the most neglected figure in the history of 18th century political thought, I will briefly present the life of Jodin because I think it is relatively unknown and because it contains certain elements peculiar to female condition during the 18th century, and then I will analyze the legislative proposition. Certainly, Marie-Madeleine Jodin had an eventful life. She was born in Paris in 1741. Her family was originally from Geneva, but had moved to Paris so that his father, Jean Jodin, could continue his watchmaking studies. It was a winning move for the father, who in 1754 presented the project for a clock with two pendulums to the Académie des Sciences, which was quite successful, and also became a collaborator and a correspondent of the philosopher Denis Diderot. One of the events marked the most Jodin's life is linked to the death of the father, because in 1761, at the age of 20, Jodin was firmed in the Salpêtrière by her uncle together with her mother. They were both accused of libertinage, and in particular, the mother was accused of having her daughter prostitute. The Salpêtrière was, as you know, a structure within the Hôpital Général de Paris, intended to house women accused of prostitution or scandalous behavior from the end of the 17th century onwards. In the aftermath of the liberation from the Salpêtrière, which presumably took place between 1763 and 1764, Marie-Madeleine embarked on a career as an actress outside the borders of France in Warsaw and Dresden. Behind the choice to leave the country, one can easily assume the will to escape the stigma that marked the women who had been locked up in the Salpêtrière. In fact, during her stay in Warsaw, an anonymous pamphlet began to circulate which insisted on the physical stigma of the scars on her shoulders as a proof of her stay, and I add the violence suffered in the Salpêtrière. Her career as an actress underwent a turning point in 1774 when she was engaged in the company of the famous Mademoiselle de Montpensier to perform in Angers. But after a week of engagement, Jodin was removed and fired with the accusation of having not respected the terms of the contract. However, we do know that Jodin successfully brought her case to court, accusing the director of the crew of making sexual claims and being dismissed for refusing to respond to his expectations. Following the clash with Mademoiselle de Montpensier, Jodin definitely abandoned the theatrical scene. We have no news of the period between 1777 and 1789, when at the time of the summoning of the Estates General, Jodin invoked the need to also call French women to reform society and to, with her Legislative View for Women. This 86-page text was addressed to the deputies of the National Assembly and to the whole French nation, and outlined the characteristic of a new legislative plan that would restore to women, I quote, the rights which are ours by nature and by the social pact. Significantly, the text opened with a dedication to my sex, followed by the eloquent statement, "and we too are citizens." Jourdain called for an independent legislative code that would eliminate what in the past have tainted the glory and the virtues of women, and she called for a new political organization that would free the French women from that kind of protection that had kept them out of public interest. Hence, Jourdain's goal is to make women legislators of the custom to reform French society. In fact, she remarked that the state of degradation in which her sex found itself did not derive from any imperfection of the female nature, but from the neglect of the laws that had allowed a scandalous license to be introduced into customs. The first point of Jourdain reform was the abolition of prostitution, because she had known very closely the reality of the femme publique locked up in the Salpêtrière. She observed that the ignominy to which your police seems to devote part of our sex to the incontinence of yours, outrages the laws and destroy the respect belonging to the sacred title of female citizens, wives and mothers. And at the same time, she denounced the hypocrisy of the Parisian policies and government. Since Jourdain's goal is to legitimize the public role of women, that is to defend the right to be full citizens, participating like their husband, fathers, and brothers in the drafting of a new legislative code, her legislative view for women dispels doubt about the ability of women to have a role in the government. Jourdain claimed equality between men and women, underlined, as François Poulain de la Barre had already done a century earlier, that the mind has no sex any more than virtues do. Jourdain's demonstration is divided into two parts, a pars destruens and a pars costruens. In the first part, Jourdain attacked the misogynistic assumption of Jean-Jacques Rousseau, Lord Chesterfield, and Louis-Sébastien Mercier. In particular, she quotes two statements disseminated in the French public opinion by Mercier in his well-known Tableau de Paris. The first quotation, originally published in Julie ou la Nouvelle Héloïse, mocks the resourcefulness and the initiative of the French women. Parisian women, accustomed to seeing men everywhere and to mixing with them, have the same pride, the same audacity, the same way of looking and very nearly of walking. Provocatively, Jourdain asked why Rousseau didn't say the same virtue, the same courage, or the same elevation. In short, she wondered why a woman who imitates men in their ambition should be mocked rather than admired. This statement of Lord Chesterfield was originally taken from the letter to his son on art of becoming a man of the world and a gentleman. In a letter to his son, the author explains how to flirt with a woman and why men and women are so different. In his opinion, women are only children of a larger growth, who are unable to reason or to act consequentially for 4 and 20 hours together. Jourdain answered to Chesterfield and Mercier's assertion, claiming the merit of the French femme de lettres, who could boast of never having insulted their male opponents, although they perhaps had every reason to. The objective of the second part is to demonstrate the political capacity of women. First of all, prejudices on the physical inferiority of women are excluded. She recalled Voltaire-Wick's constitution as a very significant case for contesting this hypothesis. And then she quoted Plato, from whom a woman's body could show the same vigor as men's if subjected to physical exercise from the earliest childhood. As a counterproof of this argument, according to a probative model that can be found through the whole work, Jourdain brought the example of women who had distinguished themselves in the most different fields, including literature and politics. In particular, she mentioned the famous example of the reign of Elizabeth I and Catherine of Russia, to recall finally that no one sex was created oppressor of the other, and this ridiculous debate of superiority are an insult to the nature. As you can see, these are the same example quoted by Condorcet. Jourdain, in fact, drawn on a rich tradition of texts about female virtue, in particular La Galerie de Femmes Fortes by Pierre Lemoine. Lastly, she had to show that it is up to women to reform custom, and presented a long series of historical and mythological examples of people who had fruitfully assigned women a public and political role. The text concluded with the proposal to convene an assembly of women that, on the model of the National Constituent Assembly, would draw up a new code of laws to reform French society, guaranteeing, beside the abolition of prostitution and the closure of the gambling houses, the institution of divorce. Unlike Olympe de Gouges and Condorcet, the task brought, albeit in different ways, for women the same political rights that the revolution was guaranteed to an increasingly large number of citizens. Jodin embraces the logic of the complementarity between the sexes, and she recognizes to women a prominent role in the legislation of custom. For Jodin, women will have to reform the custom of French society, and their law will constitute a code parallel to that of men. They will therefore not be called upon to legislate on the same topics. However, the three proposals share two assumptions, I think. Firstly, the idea that women have natural rights that society and prejudice have stepped on. Secondly, the need to call women to play a public role in the society by claiming, beyond their full intellectual capacity, also the usefulness for the community. As Charles-Guillaume Tereman argued in 1799, a republic will never be solid if women are not faithful to it, or if they do not feel tied to it because they did not play any role in it. As we know, the French Revolution did not accept these demands. Condorcet himself did not include this theme in a draft of the constitution he drew up in 1793, but certainly it is precisely in the French Revolution that, as Linant has written, we found the roots of women's rights, which were acknowledged only a century and a half later. Thank you very much.